It is time for us to start. We've also formed a quorum. So I call the meeting to order. Well, as to the papers issued since the last meeting, please take a look of our agenda. There's only one item. Item 2 on the agenda, matters for discussion at our next meeting. Please take a look of paper CB bracket 4/455/2024 bracket 01. We have a list of outstanding issues. Well, on the 27th of May at 4:30 p.m., also a Monday, we are going to have our next regular meeting. And we will look at the two items proposed by the administration. First of all, sports dispute resolution and its prospect in Hong Kong. And secondly, the promoting the use of mediation in court proceedings. Any suggestions or comments regarding the two items? If not, then we will adopt those two proposals. And then we come to the third item on the agenda, which is the first discussion item for today. So please invite the relevant officials to join us. Well, please take a look of paper CB bracket 4/2024 bracket 02. For those who would like to speak, please press the request to speak button. I would like to welcome Mr. Horace Chang, Deputy Secretary for Justice, as well as his team. I'd like to welcome the representatives from the Hong Kong Bar Association and the Law Society of Hong Kong. I'd like to give the floor to the Deputy Secretary for Justice, Mr. Horace Chang. Thank you, Chair. Members, in relation to mediation in Hong Kong, it is undergoing development. And in fact, the relevant laws have provided a robust legal structure for mediation services. And in fact, we have already set up the Hong Kong Mediation Accreditation Association Limited. That's for the accreditation of mediators. And then we have also got the Mediate First Pledge campaign, the Mediation Week, Mediation Conference, etc. It shows our earnest efforts to promote mediation. Mediation has become one of the effective options for resolving disputes. On such a basis, the DOJ will continue to promote this policy and will deepen the mediation culture. We'll also promote Hong Kong as a center for international legal services and dispute resolution services in the Asia-Pacific region. I'd like to take the time to look at the policy issues under the 2023 policy address of the CE. In the CE's 2023 policy address, in to the deepening of mediation culture, the DOJ has come up with three major policies. First of all, we would like to promote standard mediation clauses. The DOJ will come up with a template so that they can be adopted by government contracts. The objective is that government departments should, as far as practicable and to the extent appropriate, first consider using mediation to resolve disputes. We would like to lead by example. We'll encourage private companies to include similar mediation clauses in their contracts. And for this purpose, we have already started an internal training. On the 19th of April 2024, we arranged a briefing session for heads of departments so as to promote the benefits of mediation. We also provide assistance to bureaus and departments in drafting mediation clauses in government contracts. Secondly, we would like to further enhance the professionalism of mediation services. The DOJ will examine and review the current accreditation and regulatory system of the mediation profession so as to align with the evolving needs of a society and to make sure that our mediation system will be relevant and is of a high standard of quality and professionalism. This can instill greater confidence in the public. We'll look at the latest developments around the world. We'll also look at the actual needs of our sector, and we'll take a comprehensive review to look at the accreditation, training, and regulatory system of our mediators. And thirdly, we will promote the application of mediation skills. We'll be having activities and we'll have tailor-made training courses so as to empower the stakeholders and the general public so that they have the ability to apply mediation and mediation skills in resolving disputes in the community, like disputes relating to neighborhood, building management, consumers and social welfare, etc. The DOJ firmly believes that this is a very effective out-of-court dispute resolution means. Mediation shows that we can have something which is mutually acceptable and timely in resolving disputes. And then we can have a harmonious and stable society, and we can also foster a culture that embraces mutual support, respect, harmony, and inclusiveness. The DOJ will continue to launch the policy initiatives, will deepen the mediation culture. This is to tie in with our objective of becoming a city of mediation service, as well as the incoming of the international organization. I would like to give the floor to the Bar Association, please.
The Bar Association supports very much mediation as obviously alternative dispute resolution, but sometimes it perhaps could be considered as the appropriate dispute resolution, and that as mediation develops, in fact, the court process is seen as the last resort and mediation the first resort. This is reflected, I think, by many, many more barristers actually being trained mediators and engaging in the process either as mediators or on the instructions of solicitors to attend mediation as counsel. And it's very important, I think, to recognise that this process has gained momentum over the last few years, and in particular, it's been proved very, very effective in the world of family disputes litigation. And the attraction of effective mediation is that it also lifts the pressure on the resources of the court process. So the Bar is 110% behind mediation. Thank you for the opportunity to express our view.
Thank you, Mr. Egerton. 而家副會長余國堅律師同埋調解委員會主席。
Next, I would like to give the floor to Mr. Christopher Yu, as well as Mrs. Cecilia Wong from the Law Society of Hong Kong. Please restrict your speech to 8 minutes. Thank you, Chair. Thank you, members. Good afternoon, ladies and gentlemen. The Law Society always supports mediation as one of the broad directions to resolve disputes. We have got two parts to our submission today. First of all, for transactional lawyers and corporate lawyers or in-house lawyers in relation to deepening mediation culture, we can play a role. We'll speak on that. As to the second part of our briefing, or our presentation, I will defer to my colleague, and she will talk about how it operates and the development. First of all, let me talk about transactional lawyers as well as in-house lawyers and their importance in deepening mediation. Currently, we have around about 13,000 members. Quite a large number of them are transactional and in-house lawyers. Mediation is voluntary and private in terms of its nature in resolving disputes. We get a neutral person, that is a mediator, to mediate between the two parties so as to arrive at an outcome. Of course, litigation and adjudication are also commonly seen means to resolve disputes. But then when compared with those two means, mediation can always give us a better or a more harmonious outcome. And of course, the other options are more adversarial, and then lawyers play a slightly different role. For non-litigation lawyers and in-house lawyers, we also have expertise in intellectual property and family issues as well. Through negotiation and consensus building, we can maximize the benefits for our clients, and we can sort of mediate between the parties. So we believe that for non-litigious lawyers and in-house lawyers, I'm sure, and we're sure that they can have an advantage, professionally speaking, in becoming mediators. Now I'd like to defer to my colleague, Cecilia, and she will continue to talk about the development in mediation. Yes, please. Thank you, Christopher. Chairman, members, all the time, the Law Society of Hong Kong supports the development of mediation, and we cooperate closely with the judiciary, the DOJ, as well as NGOs, so that we can achieve our objectives in the development. Say, for example, the Law Society in relation to CAP 620 and CAP 631, as well as paragraph 31 of the Code of Practice, namely the Mediation Ordinance, Apology Ordinance, come up with our submissions. And we have been providing training and courses. And in the light of the differences of different kinds of mediation process and needs, we have come up with different publications. And we have model clauses. And we have provided appropriate training modules for lawyers. We have CPDs annually for lawyers, and they are centered on different themes of mediation. Say, for example, for apology ordinance, CAP 631, whether it has an impact on mediation ordinance. And recently, as to the sharing session, we have also got a sharing session concerning mediation. We try to tell lawyers how mediation can apply in our different fields of work, as well as the knowledge and skills needed by lawyers in such an area. We'll continue to provide a good service. For mediation, all the time, the Law Society of Hong Kong has been cooperating with the SAR government as well as the mediation sector. We tell the public how mediation can be an effective means of resolving disputes. We have also signed the Mediation First Pledge. We have explained the details to the public. On many occasions, we have rendered support to the government in relation to mediation activities, like the Mediation Week, and we have been explaining to the public the latest development of mediation. And we have also got a mediation hotline for the public so that we can provide free mediation inquiry service lasting no more than 45 minutes to members of the public. We have had a law week so as to tell the public what it means by mediation and dispute resolution. We have also got cooperation with 4 organizations providing service in mediation. And in fact, we have got the JMHO. We have also got FDRC for financial disputes. We have also got the HKMAAL, Hong Kong Mediation Accreditation Association Limited. For HKMAAL, it is the only organization accrediting mediators. And we have also got, we have been supporting EBRAM. And we have been rendering support from the outset, and the Law Society will continue to render our support in relation to the above-mentioned organizations. And in fact, this year, the International Rotary Club as well as the JMHO have organized, with support from the DFJ, the 7th competition for secondary students in relation to mediation, so that we can promote the concept of mediation to secondary school students.
And the Law Society also launched various pilot schemes to let the public experience mediation service. For example, in 2018 to 2022, the Law Society supported the organization at West Kowloon Mediation Center carry out a pilot scheme to deal with cases referred to the Small Claims Tribunal. The pilot scheme dealt with 1,300 small claims tribunal cases in order to further promote the development of mediation in Hong Kong, and also to support the plan of the 14th 9-year plan promulgated in China, and to promote Hong Kong as an dispute resolution center in Asia Pacific region. The Hong Kong SAR government should continue to inject stable and continuous services and support and resources to foster the sustainable development of mediation, and also to provide for the public affordable, professional, legal mediation dispute resolution services. We believe that all this can help strengthen the mediation culture in Hong Kong and enable its sustainable development. Thank you. Thank you, Mr. Yu and Mr. Swong, for your introductions. Questions? 4 members have pressed the button. They are Priscilla Leung, Carmen Can, Yong Ho Yan, and me. But according to normal rule, I will be the last one to talk. Priscilla Leung first, please. 5 minutes, including answers. Thank you. First of all, I'd like to say that I'm very much in support of deepening the mediation culture. To me, mediation as a way to resolve disputes to the society, and in terms of public interest and for various sectors, and also in terms of use of our judicial resources, is very helpful and useful. In 2019, I was a directly elected LegCo member, and back then I tried very hard to resolve disputes between building management committees. So I very much hope that the government could set up a mechanism to resolve management committees disputes through mediation, because there are many families which were not in a position to engage in litigation because the cost was too high. So I do think that in the society there are lots of disputes which are not appropriate for dispute to be resolved in court. Because once the dispute is resolved, the whole family also disintegrates. But what is comforting to me is that besides the neighborhood disputes, family disputes, or in the community level, which also is on top of commercial disputes and international disputes, Hong Kong is in a blessed position in that the country actually allocates to us the status of international mediation. In the Greater Bay Area, I think that is a very good way forward. I was involved in a commercial dispute resolution, and in a big case, you can, through mediation, resolve it very quickly, effectively. So it's a triple win situation. In some cases, with mediation training, we built up a good reputation for Hong Kong, and that also can bring to us more business opportunities. So the kick would certainly be getting bigger and bigger. I can see that right now in Hong Kong, we have a full mission ahead to promote the use of mediation for commercial and civil disputes. And under the banner of common law, I think the government can take the lead the quality is also important. Of course, the legal sector enjoys an advantage, but I can see that throughout the years, I was teaching law at university. I found that, psychologically you want to resolve a case, but when it comes to international disputes, there could be political considerations behind. It's not like just citing the law. That is not enough in resolving a dispute. So therefore, the training should involve not just the legal knowledge as what the Department of Justice has involved. You need to, besides international law or the procedures or skills in mediation as part of the training, that they are all important because mediation involves settling a dispute beyond the court. But when it is at the level of international mediation, the wisdom and training and professional requirements needed would be much higher. So our country actually pins much hope on Hong Kong. I hope that when you help us train the talents for the sector, of course, our nation has its own arrangements. I believe at a high level, there will be national considerations for resolution of international disputes. But I hope that our own talents nurtured here can possess various skills so as to meet the requirements needed for, big dispute resolution or mediation work. So which may take more than what we are offering now in terms of training. So you're expressing your view. Any questions or response? Thank you, Ms. Leung, for your valuable comments. Truly, as Ms. Leung just said, well, with the full support of our nation, we are in a position to settle international disputes. Mediation is actually a good chance for us to actually broaden the outlook of mediators. Mediation training, of course, is important at the community level or in the neighborhood level, like water leakage in a flat, for example, noise dispute, or even at the level of national disputes. We need to be actually equipped to handle a variety of cases. And in many cases, taking the case to court may not be the appropriate way forward. And because, importantly, we want to maintain or preserve the good relationship between the disputed parties. So if you lose a court case, the relationship could deteriorate. So mediation can, after a dispute has been settled, the parties involved can maintain a positive cooperative relationship. That's very important and useful. Therefore, in Hong Kong, particularly in the Chinese society, I think that mediation is something that is in tune with our culture and is worthy of our promotion. I think as we have the mediation office fully set up and training in full gear, we will definitely take into consideration Ms. Leung's views. Kong-Macao, next. Thank you, Chairman. I'm speaking to support the deepening of mediation culture. The key is how we're going to do it. When it comes to the deepening, I'm sure we all support it. And I've heard from the two lawyers groups that they do support the idea. My question is about paragraphs 8 to 13. In paragraph 8, it says that in government contracts, it's planned that the mediation clauses, templates for mediation clauses will be included. That is model clauses, so as to ensure alignment. We haven't done that yet, I know, but in paragraph 9, it mentions that we should encourage private companies to do the same. That would be a good contribution to promote the mediation clauses to the community. And it should not be just done by the DFJ. Just now, the Law Society mentions a number of organizations. I think we can ask those organizations to help promote those templates for us. In paragraph 10, it says that the Hong Kong Mediation Accreditation Association Limited has operated for more than 10 years. So in the comprehensive review of it, what's the role of the DFJ? That's my question. And in paragraph 13, it says that to enhance Hong Kong's status as a center for international legal and dispute resolution services in Asia-Pacific region, of course, the DOJ will continue to implement the necessary measures, and I will support that. And lastly, on the whole, we've heard from views from various mediation organizations that their organizations and platforms, can we make them known to the public, whether it's the Bar Association or Law Society, so the public know better the advantages of various mediation platforms or their characteristics. Some may specialize in civil neighborhood disputes, simple disputes like water leaking in a residential flat, or cheaper mediation to deal with neighborhood disputes, and which organizations have more specialists to deal with commercial disputes, or EBRAM. Would it use technology more, or is it more suitable for mediating cross-boundary cases? Or are there any organizations that can use various languages in doing mediation, or using voice-to-text services and so forth? So we should let the public know and distinguish more easily, conveniently, the characteristics of different mediation platforms. I think nowadays people don't know much them now. How can we? Well, we all say that this is a win-win situation, but can we tell the public what are the different characteristics of the different organizations? So, yeah, question in relation to question 13. Yes, of course, Ms. Khan mentioned that, first of all, as mentioned in the paper, lately, the secretary also at the with government departmental heads, he arranged a briefing for them because we knew that we want to promote the use of standard mediation clauses in contracts. Then people will ask, is the government taking the lead? So we must take the lead and set an example. And the secretary, therefore, arranged for all department heads within the Hong Kong government to sit down for a briefing. The secretary explained to them the benefits and the operations of mediation. And the DOJ also pledged that if any department needs to use those clauses, we will help with the drafting so that the government can really play the role of taking the lead. And at the briefing, I was there too, and I can see that our departmental heads, first of all, they were very positive in relation to the mediation approach, and they were very interested and hoped to get more help from the DOJ. So after doing that, we hope the commercial sector can also follow suit and promote the culture of mediation. Ms. Khan also mentioned about the diverse mediation organizations in Hong Kong. Sometimes they would accredit different mediation qualifications. Well, we have such a flourishing scene here. But I agree, in the days ahead, we need to consider how to help these organizations find their niches. For example, specializing in financial mediations, or specializing in insurance, settling insurance disputes, or those specializing in settling real estate sector disputes. So I think we will look into the matter with the sector more. And as for professional accreditation, for the latest development, I will ask my Principal Government Counsel, Mr. Tuffers, to give us some ideas. Thank you. Thank you, Ms. Khan, for your question. I'll be brief. As member has noted, the DOJ's new policy is to tie in with government's plan to be a center, international capital for legal and dispute resolution, and also to take forward the standard mediation clauses. That's part of the overall policy. We need to have a comprehensive review of what more to do, also of HKMAAL, because it has operated for more than 10 years. So the DOJ would play the role of having a detailed internal review, making reference to other jurisdictions to find out in Hong Kong at this moment what is the room for improvement, what should be improved. We also will look at the functions, the terms of reference of HKMAAL, and to see what stage of development it is at and what more can be done. That will be the angle of the review. Can you focus on the main points, please? After the review, we would also collect opinions from the sector and decide the way forward. Thank you. Ms. Yong Ho Yen?
Thank you, Chair. Well, in recent years, when it comes to the promotion of mediation and mediation first pledge, the DFJ has done a lot. There have been a large number of activities, like different sorts of competitions and peer competition in secondary schools. They are new items introduced this year. I think we have to promote it at the community level. I'm a general mediator, also a mediator for family issues. I think the mediation skills would benefit the society. We need communication skills. We need to know how to listen actively, and we need to have the skills to express difficult opinions. Yes, for mediation, it's mainly for individuals and corporations. But what about government departments? Have they also signed the mediation first pledge? When departments are dealing with the public, I think they may need mediation service. Of course, for the mediation center, there's more for individuals when they have disputes. But what about promoting the mediation culture and how the skills can be useful and inspire everybody? I think there's room for more public education. Now, at the forefront, of course, it will be the care teams that will be approaching the public. Will the DFJ consider providing training to district council members as well as the care teams who will be working at the front line so that we can apply the mediation skills extensively? Many citizens know about mediation, and they always thought that mediation would only be needed when they were caught in a court case. But in fact, this is not true. And I hope the government can tell the public that mediation can be resorted to even before there is litigation. So it's better for us to deepen the mediation skills instead of just telling people that we do offer the service of mediation. In other words, you need to be more proactive and educate the public about the skills involved in mediation. Thank you. Thank you, Chair. Thank you, Ms. Young. Yes, public education is important. We need to tell the community what is meant by mediation and what are the benefits. We know that in the society, members of the public may not know exactly what is meant by mediation and how it differs from arbitration. Doesn't mean that by mediation we leave the matter to the two parties involved to resolve the dispute. Having explained the benefits of mediation to the members of the public, they will always say that, well, perhaps this is a feasible option. As I have said, it can maintain the relationship between the parties to the dispute. It is less costly, and there is no fixed rules. Now, if A owes B money, does it mean that the only options would be repayment or no repayment? Well, in fact, there can be other alternatives like repayment plus an apology, and they may not be available to the court. So there can be more elements than just the set options. Having explained the nature of mediation to the community, many people become interested and they think that probably mediation can be the way out. As Ms. Young has suggested, we have to have more public education, and that's why we have the mediation first pledge. As to whether we can sort of make greater use of their care teams, perhaps I can defer to my colleague to explain the details. Yes, thank you, Chair. Well, in fact, we do have support from individual departments like the FHD, etc. And in fact, we do have cooperation activities with departments, like in the form of seminars, etc. So we do promote mediation on such occasions. As the Deputy Secretary has said, we need to do more. So we want to lead by example, and we hope that in terms of our mechanisms, we can further give recognition to mediation, and that's why we are coming up with the standard clauses for government contracts, and we'll try to see what will be needed by different government departments at the front line. We'll try to tailor-make our service, and then we'll go into the community. As the Deputy Secretary has said, we'll approach the district councillors as well as the care teams, and we will develop the details when we reach to that stage. Ms. Young, well, I hope we can maximize the benefits of mediation. It isn't a matter of I teach you how to mediate. In fact, I think mediation skills will be needed by everybody when we encounter disputes in the community. I think it is a suggestion. Next, Mr. Dennis Leung. I support the government's effort in doing more to promote mediation. After all, mediation is the trend globally. As Mr. Zhang has said, we hope we can dispense with an increasing workload for the court proceedings. It will be timely, it will be resource intensive, so we can consider mediation. And before we go to the court, we can try to resort to mediation. What is important is that even before the legal proceedings have started, mediation can be considered by the parties to the dispute. Sometimes, even if you can win a court case, you may lose your family. Sometimes people are just very argumentative. They would rather go to the court than resort to alternative means of dispute resolution. I had this very bad experience. It was something very simple. It's about property management or personal disputes. But then the other party insisted on going to the small claims tribunal. But before the proceedings started, we were advised by judiciary to go to a room to sit down and try to see if that can be resolved. I represented the owners corporation, and we were most willing to have mediation to overcome the issue. But then the other party, the counterparty was most unwilling. Sometimes we don't need to take the landlords or the tenants to court. Well, in fact, we can always have a dialogue and resolve the matter. But then there are always some people who don't like that and who insist on going to the court. So I just wonder if we can change the court rules. That is, as long as one party is willing to adopt mediation, the court can be more facilitating. And can we not spare more resources on convincing or persuading the unwilling party to consider mediation? I think in the past my experience was that if either one of the two parties to the case is not willing to try mediation, then mediation will be out. So perhaps the government, the DFJ, can consider the way forward. That is, whether we can sort of improve the procedures so that the mediation can be more facilitated. And of course, public education would also be important. I hope the government can take on board my view. Indeed, this is your suggestion. Mr. Zhang. Mr. Leung talked about his experience and he cited examples. That is, there were people who were adamant in not trying mediation and were insisted on going to the small claims tribunal. Well, I think if you look at it from another perspective, is that they have trust in the judiciary and they won't resort to barbaric means. Well, I was a lawyer. Experience told me that from the beginning, parties to a case would be resolved to go to court. But then as time went by, they had to spend time and money on paying for the lawyers' legal services. They started to regret. And then they found that it was no fun to get caught up in a court case. So before entering the court procedures, we should try to advise them that they could perhaps try mediation. We have been talking to the mainland commissions and ministries. Well, on the mainland, if everybody rushes to the court, then it would be very sort of it will be adding to the workload of the courts. So they will try to look at the fundamental issues. That is, they try to tackle at the source, at the root. Just like in environmental protection, they try to address the question or the problem of waste at source. The same is true for court matters or disputes. So well before court cases start, we tell them about the beauty of mediation, and we try to tell them that it's less costly. And in fact, there's another beauty that is easier to enforce the outcome of mediation. Now, if the two parties go to court, the loser may only get the winner may only get an empty judgment, because at the end of the day, it may not be enforced. But for mediation, it's more likely that the outcome can be enforced. So we should educate the public so that even from the beginning, we can convince them that mediation is a worthy option for consideration, so that it can be it can exert less pressure on our judicial system. Mr. Holden CHOW, when it comes to the promotion of mediation, I think we have all done a lot. And for those who are in the legal circle, you would understand that about 10 years ago, there was the civil justice reform. Back then, there was already the idea to promote mediation. If mediation was not tried at all, then courts would become an important factor. I think lawyers or legally trained people would understand this point. In recent years, I know that the government has put in a lot of resources, like the Integrated Mediation Center in West Kowloon. Space is available for mediation to take place. All such are good. Let me then come to another point. Earlier on, my understanding was that at West Kowloon, the government has this integrated mediation center. They are not just providing a venue. I know that if the judiciary can arrange for mediation, then they will look at the list of qualified mediators to provide the service. My understanding was that earlier on there were mediators who helped out. Is it right for me to say that they were not paid? That is, if you mediate via the integrated mediation center, you don't get paid? Is there any honorarium or travel expenses? Earlier on, my understanding was that it's a sort of a voluntary service. Of course, those who were involved were sort of community spirited. But then I would suggest that please at least give them some traveling expenses as a token. So please sort of clarify this point. Yes, again, I would like to defer to Mr. Tavis. Yes, between 2018 and 2020, for the mediation center, it was coordinated by an independent operator. So financially speaking, the mediation service provided there did pay the mediators. It was a pilot service, a pilot scheme. It ran between 2018 and 2020. The outcome was regarded as good. There were 1,300 cases, and the success rate was quite high. It was more than 50%. In the light of such an outcome, we had a word with the judiciary. In the year 2022, they took over, and currently they have a list of mediators, but then they're providing service on a pro bono basis for no fees at all. So it's a pro bono. Is provided on a referral basis. So we provide assistance to those who are involved in small claims cases. That is, if the adjudicator thinks that it is good to refer such cases to the West Kowloon Center, then mediators will provide service on a pro bono basis.
Thank you. Thank you for your explanation. But what I'm saying is, well, we all know that the mediators were doing it on a pro bono basis, but we think that they have the heart. Should we give them some travel allowance, some kind of compensation for them? Would you consider that? That's just my suggestion. You can consider that later on. Yes, opinion noted. We'll look into that. Vice Chairman, well, having heard your opinions, and I think that you all agree mediation can resolve disputes a good way. We all support it. But just talking is not enough. You need to have the resources and promotion. I remember more than a decade ago, the Department of Justice started to integrate mediation services across Hong Kong. I'm sure Mrs. Wong, back then, I think we were at the same committees having meetings, right? And there were no resources then, and the Law Society was asked to provide secretarial support and so forth, and other resources. Now time has passed. Well, DFJ is so supportive of it, but still the money issue remains. For example, the DFJ or the government, would they provide resources, for example, in terms of avenue for mediators to use, or training, or the community care teams members, if they want to take a course in mediation, can they apply for any support? Secretary? Thank you, Vice Chairman. You're right in saying that resources are important consideration, whether in terms of provision of venues or training. Of course, well, in promoting mediation, should we come across the need, we would make suggestions to the government in relation to provision of resources. On the other hand, we need to think about, well, this is just my preliminary thought. We need to look at the specific needs of different sectors and act accordingly. As I said in my introduction, for example, issues related to building management, there could be particular training for mediators specializing in resolving those disputes to help residents resolve their neighborhood or disputes affecting or related to the building. There could be financial, real estate disputes, and so forth. In different sectors, there could be specific services provided, so that could mean better use of resources. In the days ahead, we would definitely, as mentioned by the Vice Chairman, we would look into how to promote mediation. In the beginning, we cannot provide services for all sectors, but if there's a big demand for particular types of mediations with a high success rate, and if we can accommodate them, we will try to do more in that area. And also, in promoting the development of mediators in Hong Kong, we would just think of Hong Kong alone. Why? Because we have noticed that in the mainland, the courts in the mainland have actually attached importance to commercial mediation. Mainland mediation is quite different. It's quite popular, but it's mediation by the people in that sense, in terms of the approaches and the qualifications of mediators, the outcome of mediation, execution of decisions. They are not the same as that in Hong Kong, but they have noticed the advantages of our commercial mediation. And some of my mainland counterparts have told me that they wanted to take reference from Hong Kong's mediation for commercial disputes. And some mainland courts have lately invited our mediation organizations to be on the list of mediators for mainland cases, so they can be involved in mainland cases. And as over the past few years, the Hong Kong SAR and Macau and Guangdong, the legal departments have setting unified mediation in terms of mediator, professional code of conduct, and accreditation of mediators and model rules. We have reached consensus. So looking ahead, we would, for the accreditation of mediators and the unified panel of mediators, we are working on that. Hopefully, within the Greater Bay Area, there will be a unified panel of mediators for the whole area coming up, so that enterprises and people in the Greater Bay Area can refer to the panel for mediators. And this can foster the development of mediation in Hong Kong. So not just within Hong Kong, in the mainland, particularly in GBA or mainland courts, as I mentioned, there are some, the list of mediation organizations in the mainland that could provide more opportunities for us to grow. Thank you. The last one to speak is me. In the paper, it's mentioned that over the years, the government has implemented various plans in order to foster the use of mediation as a way to resolve disputes. For example, mediation first, the small claims pilot scheme. But based on the information provided by judicial organizations, the small claims cases, there were more than 52,000 cases last year, but only 193 cases went for mediation. And in the court of first instance and district courts, only 609 cases sought mediation, less than the number the year before. So it seems that the progress in mediation is not ideal. So has the DOJ looked into why mediation still is not the choice for many people? Would you review what are the reasons behind? Would you review the content of and the effectiveness of the various pilot schemes, or to beef up your promotional campaigns so as to improve the usage rate? Yes, in Hong Kong, promoting mediation can be improved, and we can enhance the effectiveness more. Therefore, we are proactively seeking to deepen the mediation culture now. And also, the secretary even introduced mediation to heads of departments. So we want to be more proactive to let various sectors know the advantages of mediation. Secondly, as mentioned by the chairman, in terms of court cases that went for mediation, the rate is not ideal. There are lots of reasons behind that. Maybe, well, in the legal sector in Hong Kong, so far, I would say that I think, well, if you are lawyers, you may know that it's rarely that lawyers would suggest to their clients to go for mediation instead of taking the case to court. So as lawyers, do you have an accurate understanding of mediation, and would you be devoted to promoting mediation as an alternative to clients? I think the sector can do more, and also for court cases in the code of conduct, for a physical death case or marital cases, the courts would ask the plaintiff to resort to mediation first. People can take the case to court directly, but if they insist on taking the case to court, then, but I think people just go through the motion nowadays. Yes, so that's the point. You're a lawyer, you understand that. Often, many clients, I was a lawyer before, many clients, before entering mediation, they were instructed the lawyer to say that, well, just go through the motion. They didn't really seriously consider mediation as an option. So in terms of deterrence or attractiveness, whether in our code of conduct for lawyers, have we made lawyers really take mediation seriously enough to recommend it to their clients? So I think we can do more to promote mediation further. Of course, in my answer to another question, for some designated areas, for example, in relation to building management, whether we can consider using mediation to resolve those disputes. For example, water leakage within the flat. And often the residents cannot afford the litigation costs, and lawyers don't want to take up these cases because they are so complicated and do not pay much. So for water leakage cases, I think mediation could be the best way to go. So can we, for example, for designated type of cases, encourage mediation more? So we can really look into it with government departments to try to promote it more. Thank you. The second round, only Carmen Khan has to press the button. I'll draw a line here. Okay, Ms. Khan. Second round, you have 4 minutes. Simple question. I just want to know the DFJ within this year, 2024. Do you have any, say, any activities to promote mediation, say in Legal Week, or what? That is to look at the positioning of our mediation center in Asia Pacific, or would you have any other activities to promote mediation? Mr. Tafas, please. Thank you. Ms. Khan? Yeah, within this year, there will be several mediation-related measures. As I said, we want to set an example, so the government internal training, it will be activated. As mentioned by the Deputy Secretary, besides after the briefing with departmental heads, we want to provide training for government departments. First of all, with the Civil Service College, will provide training on mediation involving various government departments. And secondly, in terms of promotions for the public, April 6th to 10th of May, it will be a mediation week. There will be conferences, and also we would, for different sectors, carry a promotion. For example, for mediation as a way to resolve office conflicts and so forth. And we also explore other international mediation topics. And also, yes, national disputes, how can they be addressed through mediation? In the past few years, on that, we have provided specific training. After the pandemic, this year, we will relaunch those training. It's mentioned in our paper. That is the financial disputes mediation training. And that is in the pipeline. And lastly, in November, during the legal week in November, we have plans to dedicate a day to exploring various ways or alternative ways to resolve disputes. Details have not been ironed out, but within this year, there will be relevant measures and activities to be launched. Thank you. So item 3 is wrapped up. Now let's move on to item 4 on the agenda, and that is the progress of the Department of Justice work in taking forward the construction of rule of law in the Guangdong-Hong Kong-Macao Greater Bay Area. Paper is CB-4455/2024-03, and that's the paper provided by the administration. So may I invite members who want to speak, press the button. And may I invite the administration to come in.
I'd like to welcome Mr. Horace Cheung, Deputy Secretary for Justice, and his team, as well as representatives from the Bar Association and the Law Society of Hong Kong. I give the floor to the DS4J, Mr. Cheung, for a briefing. Thank you, Chair. Good afternoon, members. As to the taking forward of the construction of the rule of law in the GBA, this has always been our work on the Department of Justice. We've been making use of different occasions and forums. Last year, we had a task force set up for this purpose, chaired by me. We have been cooperating with different stakeholders and organizations. We have been involved in studies, research, etc. In this way, we can keep listening to the views of different stakeholders. Last November, we came here to brief you on the work in the GBA. Today, we are glad to report to you about the progress of our work in the construction of rule of law in the GBA. Well, this year marks the 5th year of the promulgation of the Outline Development Plan for the GBA. And for the first time, we have published this booklet or this publication, Action Plan on the Construction of Rule of Law in the Guangdong-Hong Kong-Macao Greater Bay Area, setting out the guiding principles as well as the development direction. And systematically, we have put together our policy initiatives. On the day of publication, the action plan was issued to all the LegCo members. And in fact, we've also attached the action plan to the paper today. In the time that follows, let me go over the highlights of this paper. As we have said, we have got this unique advantage in the GBA, that is one country, two systems, and three jurisdictions. And to echo this, we have the 3 interfaces, 2 connects, and 1 GBA as our guiding principle and the development direction in the action plan. First of all, 3 interfaces, namely the interfaces of mechanisms, regulatory frameworks, and legal talents. They will be interfaced organically. And we have the following 4 items. In relation to the specific measures, I will continuously facilitate communication and collaboration under the existing mechanisms, like the GBA Task Force, the Guangdong-Hong Kong-Macao Greater Bay Area Legal Department's Joint Conference. Secondly, we establish with the Supreme People's Court a standing interface platform so as to take forward the practical work and research on judicial and legal matters relating to the GBA. Thirdly, we will actively follow up on the implementation of various mutual legal assistance arrangements in civil and commercial matters. And we will strive to enhance the arrangement for service of judicial documents between the mainland Hong Kong. And fourthly, we have a new initiative. We'll promote the establishment of a Guangdong-Hong Kong-Macao Greater Bay Area Legal Information Platform to link up the official channels of Guangdong, Hong Kong, and Macau and pull together the information related GBA's legal and dispute resolution services. For the interface of regulatory frameworks, there are 2 areas. First of all, market interface will actively seek to expand the scope of the measures allowing Hong Kong invested enterprises to adopt Hong Kong law and allowing Hong Kong invested enterprises to choose for arbitration to be seated in Hong Kong. And then the second interface is interface of professional services. And we will promote the unified model rules on mediation and arbitration, including promoting the Guangdong-Hong Kong-Macao Greater Bay Area Mediator Accreditation Rules promulgated on 28th of March 2024, and fostering the establishment of a panel of GBA mediators and a panel of recommended GBA arbitrators. We'll continuously take forward the establishment of an online dispute resolution platform in GBA. There will be 2 other new measures: actively promoting Hong Kong mediation organizations to become specially invited mediation organizations of the GBA mainland courts to handle commercial mediation cases, and actively prepare for the organization of GBA mediators training programs in Hong Kong to enable practitioners to fulfill the relevant qualification requirements for GBA mediators through the programs. And we need to have interface of talents as well before we can maximize the potential of the GBA. And it means we come to the 2 connects, the connectivity of the hardware and software in the construction of the rule of law in the GBA. There are 2 aspects in relation to the legal talents. as the CEO has said in the 2023 policy address, will be setting up the Hong Kong International Legal Talents Training Academy. We hope that we can train up more foreign-related legal talents in the region who have a global vision and be conversant with international law, common law, civil law, as well as our country's legal system. And in the GBA, for GBA lawyers, will continue to support GBA lawyers in developing their legal business and will organize practical trainings for them and will take forward the establishment of a platform designated for GBA lawyers. We'll also set up high-quality platforms for visits and professional exchanges among the legal and dispute resolution professions in the GBA. So we'll be having interfaces of mechanisms, regulatory frameworks, and legal talents, and we'll have the two connects connecting the hardware and software so that we can eventually achieve the goal of one GBA with a view to capitalizing on the respective strengths of the different cities and legal systems in the GBA for mutual benefit and synergy. We'll spare no efforts in cooperating with the stakeholders, like the mainland ministries and commissions. There will be more collaboration, and we'll be having sharing sessions with different stakeholders. We will be coming here to brief the panel members on our progress. We hope that we'll continue to have your support on our work in the construction of rule of law in the GBA. We welcome suggestions and advice from you. Thank you. Thank you, Mr. Chiang. I'd like to give the floor to the Bar Association, Mr. Edgerton. Chair, I will be speaking on behalf of the Bar Association. Sorry, it's Ms. Ho, right? Ms. Ho, member of the Bar Council. I'd like to thank Mr. Cheung for his opening remarks. We are most encouraged by the suggestions in the action plan. You have the full support of the Bar Association. As mentioned, 3 interfaces, 2 connects, and 1 GBA. We would like to take a look of our work in relation to the interface of legal talents. First, foreign-related legal talents. Hong Kong is the only place that practices common law in our country. And we do attach a lot of importance to the training of legal talents, and we have done a lot. Currently, together with the Beijing University as well as Holden University, we have common law training modules for the undergraduates as well as the graduates, and we have been using English as the teaching language so that students can learn more about common law, adopt the vocabulary, and how to handle the cases. In January, we visited different organizations in the GBA, like the Department of Justice in Guangdong, and for foreign-related lawyers, we'll be having a common ground for the training. I know the DFJ is also actively preparing for the setting up of the Hong Kong International Legal Talents Training Academy. We are most happy to provide our input. The Bar Association has been approached by different organizations to provide training for foreign-related legal talents. We hope that under the leadership of the Hong Kong International Legal Talents Training Academy will be more effective, and we can have unified and common outcomes. And then, of course, this year sees the 4th year of the GBA Legal Professional Examination, and the threshold has been lowered from having 4 years experience to 3 years. That's good news for young lawyers. Younger barristers are very passionate, and then for those who are of an older age, they may have more factors to consider. So when it comes to publicity and assistance, we do tailor-make our advice and assistance. The DFJ has talked about platforms and assistance. Maybe you can have different emphasis. A more senior barrister and a younger barrister may have different considerations. And then for publicity and education, we have to sort of tell our good story to the world. This year, the IETC held a conference in Hong Kong, the first ever such a conference in Hong Kong. We're able to attract over 100 professional legal professionals to come to Hong Kong from different parts of the world, and they can know about our strength in mediation, etc. And the Bar Association will go to Chengdu, and there's a Hong Kong Sichuan exchange session, and we will sort of publicize our efforts in the construction of rule of law, and we hope that more will be attracted to use our service and the GBA lawyers. So in summary, we support the DFJ's efforts in the construction of rule of law in the GBA. We'll try our best to dovetail the work of the DFJ. Thank you very much, Bar Association, for your submissions. Next, Mr. Christopher Yu from the Law Society of Hong Kong. Thank you, Chair. Well, we are glad to note the action plan published by the DFJ in relation to the construction of the rule of law. And the basic principle is 3 interfaces, 2 connects, and 1 GBA. And the DFJ has said that there will be more collaboration with the stakeholders. For many years, the Law Society has taken part in the construction of rule of law in the GBA, and we have been exploring the business opportunities in the GBA, and we have been rendering assistance to our members, in particular in getting the qualification of becoming GBA legal professionals. For the action plan, I would like to sort of share with you our response concerning the highlights in the paper. For the action plan, it mentions the 3 interfaces, interfacing the mechanisms, regulatory frameworks, and legal talents. For the interfaces of mechanisms, for our society, there was a joint conference for the GBA lawyers, so that the lawyer associations in the 3 places took turns in chairing the conferences, and we have exchanges concerning the legal business in the GBA. In the year 2023, on the 11th of February last year, we were the secretariat on a roster system, and were responsible for coordinating the liaison work of the joint conference. As to the second point, that's in relation to the interfacing of regulatory frameworks. Well, for the GBA legal professional examination, you know that it was a 3-year pilot scheme. It was first launched in 2020. This year, for the first time, the candidate's qualification has been lowered from 5 years to 3 years. We do welcome such a change, and the Bar Association, the Law Society just paid a visit to Beijing, and we have come back with some updates. For GBA lawyers, there are 371 lawyers who passed the exam. 329 are solicitors. So in relation to this point, we are very glad because in this way we can take part in the GBA business to a greater extent. And then in the light of the GBA development, in December 2010, we established a study group on GBA, and we've engaged an organization in publishing a paper that is the first stage development of legal business in GBA. Well, as stated in the title of the paper, we would like to help our lawyers to understand the status quo of the 9 cities in the GBA, covering the demand for legal services. And we also talked about policies pertaining to places like Qianhai, so as to enhance our competitiveness in the GBA.
On interface of talents, under the 14th five-year plan of the country, and also the outline development plan for Hong Kong-Macao Greater Bay Area, the central government proposed that Hong Kong as a center for mediation and dispute resolution service in Asia Pacific. Hong Kong Law Society is very willing to set up or make Hong Kong a base for training legal talents. The Law Society in the past for many years has staged for mainland law students and practicing lawyers different kinds of training. For example, just in since 2019, we have been on an annual basis offered by Peking University a 32-hour legal service. In the days ahead, we plan to provide People's University and Zhengfa University in China providing relevant services, legal services for them. I hope to also talk about our direction ahead. To sum up, first of all, some data. In 2023, Law Society in the Greater Bay Area carry out 11 face-to-face exchanges and coordinated 12 face-to-face and online conferences with different international organizations involving different organizations and also those in Greater Bay Area. In the days ahead, you may know that actually under the two sessions, there is the decision to develop high-quality growth and also new productive force. So the Law Society and the sector are now deeply thinking about what the legal sector can help the nation promote quality workforce, including in the Greater Bay Area. As I said in what we just discussed in item 3, mediation is a good way forward. The Law Society will continue to help foster exchanges between legal sectors in Hong Kong and GBA, and also with the sector as a whole collaborate in promoting the legal development in Greater Bay Area. That's the end of my report. Thank you, Mr. Yu. Very rich content. And also we can see that the Law Society has done a lot. Questions? 4 minutes, including answer. 5 members have pressed the button. Maggie Chan, Carmen Kan, Yong Ha Yan, Holden, CHOW, and Professor Priscilla Lau. Because of time, I think 4 minutes, including answer for each, please. The first one is Maggie Chan. Thank you, Chairman. I'm very much in support of the action plan for development of rule of law in the area. For cross-boundary civil and commercial matters and the delivery of judicial documents in 6B and C of the paper, and also in action plan paragraph 18, it's mentioned that we should carry out a standing platform with the Supreme People's Court, and also we should follow up on various civil and commercial cases, and Hong Kong and mainland judiciary mutual service of judicial documents. Actually, the delivery of documents between Hong Kong and China has been an issue. Even though Hong Kong and mainland courts, they have written documents, but it takes time for documents to be delivered in time. Now, with the e-delivery service available, I would suggest that maybe we should integrate e-delivery and usual delivery. Would the DFJ consider looking into establishing an official mutual delivery of judgments involving civil and commercial cases? And there also be, would you consider setting up of an e-platform as well, so that there can be a pilot scheme, some sort of pilot scheme, to have an e-announcement of judgments. When the time is right later on, we can further on allow for Hong Kong, Macau, and Guangdong to have, well, similar to Gazette in Hong Kong, or to take out advertisements in newspapers on notices of court judgments, so that the delivery of court judgments could be more efficient. Nowadays, whether it's arbitration or other cases or some domestic disputes, often we can actually take out advertisements to inform the public of a court notice. But if you have an e-platform, even if someone could be hard to track or trace, and then that would be at a mature stage. We have such an e-platform. That's my suggestion. Would you look into that, the DFJ? Deputy Secretary, thank you. Vice Chairman, yes, she was right. When it comes to delivery of legal documents, the sector always has similar concerns. They feel that that there's so much that needs to be done. We are aware of this concern, and I can tell you that in the past year, on the delivery of legal documents, we have begun work and discussed with the Supreme People's Court. It's more than we've gone beyond the studying stage, but we have not come to any conclusion and cannot give you the final decision yet. But I can tell you that, as what Ms. Chan mentioned, there are modes like e-delivery of documents which are actually undertaken on the mainland, which is not the case in Hong Kong. But with the relevant department, all your suggestions we have thoroughly considered and discussed with our mainland counterparts. In the past year, we have made remarkable progress. Our secretary, when he was visiting Beijing, he discussed the matter with the counterpart, and also we kept discussing and had numerous meetings. I expect that within this year, we will reach a breakthrough and we can announce to you our latest decision. So please give us a little bit more time so that we can conclude the discussions with them. I believe that within this year, we will have new arrangements agreed on that can help the sector in Hong Kong in relation to the delivery of court documents. The second one is Carmen Khan. Thank you. Chairman, I would like to say that I very much welcome the release of the action plan by the DFJ. This action plan seizes the main points in terms of 3 interfaces, 2 connects, and 1 GBA. This can actually have interfaces of regulatory mechanisms, frameworks, and talents. I very much agree with this direction. Whether it's a seat or not depends on how you implement it. I'd like to ask in particular for paragraph 21 to 24, interface of regulatory frameworks. In terms of Hong Kong law for Hong Kong investor enterprises, paragraph 20, it says that now in Hong Kong enterprises registered in Shanghai, even if there are no foreign elements, they can choose to go for or buy by Hong Kong law. We know about the Shanghai plan. There's a legal basis for that, and the Supreme People's Court also provides some empowerment. So if we want to, want to extend that to all the 9 cities in GBA? Or do we need any support from the mainland? Are we moving in that direction of extending it to the entire region? Or is it just our own option, our own preference to have Hong Kong investor enterprises going for Hong Kong law? And paragraph 24, I also support the direction mentioned in paragraph 24, particularly for mainland investors to actually enter the Chinese market, or foreign enterprises enter Chinese market using Hong Kong law, using Hong Kong as a gateway. I agree with that direction. And also can also allows mainland enterprises to go beyond China, using Hong Kong as a springboard. So also for paragraph 31, in terms of talents, in the International Legal Talents Training Expert Committee, what is the latest with it? And also, who are the people targeted by this training plan? Does it include overseas experts? Because you see that you will have a local and overseas experts on the committee. So who are the target people to be trained by this committee? Okay, one is the Hong Kong enterprises opting for Hong Kong law, and then also the GPA region and the legal training committee. Yes, you're right. For the Hong Kong invested enterprises using Hong Kong law, yes, in Shanghai, we had a pilot scheme and the outcome was very positive. So this approach is very much welcomed. In the past 1 or 2 years, we are trying to actively extend this idea to the entire GBA area. But Shanghai is different from other cities in Greater Bay Area because Shanghai itself has its own power to enact laws. Therefore, it can, through its own laws, implement the Hong Kong investor enterprises adopting Hong Kong law approach. In Guangzhou, it doesn't have that kind of power to enact laws, so we need to abide by all the mainland laws. Therefore, in making the arrangement, we need to consider how we can resolve the legal differences between the places. And that's what we need to do before we can extend the approach to the entire Greater Bay Area. To extend it to the area, it's not something that we, SAR, can do. But it's not just our own thinking still. In the past few years, we have discussed it with various departments on the mainland, and they have been very actively helping us adopt the approach. But we need to go for a different approach than what is used in Shanghai. But we would try to find a way that is suitable for mainland. But is it going, can we just jump from Shanghai to the entire of GBA? May not be the case, but we can try to, we will hope to try to extend the arrangement step by step in the GBA. For the Legal Talent Training Academy, yes, on the basis of the policy addressed last year, within this year, the DFJ needs to set up the preparatory office and also the expert committee. Setting up these 2 areas would be finished. It will be finished this year. And as also mentioned in the policy address, overseas and local experts will sit on the committee. As for target trainees, after the office is set up, the office will help us find what is the way forward in terms of legal talents training and what is the best way to set up the academy. Our thinking is that besides our SAR, we would also provide training in the mainland, and later on we can extend our training to other countries like those on the One Belt One Road initiative. We would do it in a step-by-step manner. We hope that we can rely on the training office and the expert committee to deal with the arrangements later on.
Any follow-up questions? No. Next, Ms. Eunice Young. Thank you, Chair. The action plan has my support. And the paper covers a lot of areas like the principles, the current mechanisms, and how the mechanisms can be brought together. And in fact, in recent years, we have seen a strong demand for that. And then for the interfacing of legal talents, I know the government would like to do more. On the other hand, the other GBA cities are working hard to attract talents. Last week in Guangdong, if you have a doctoral degree in legal studies or technology, you can get a scholarship, you can get money for research, and you can be connected or networked with the relevant organizations and corporations. Well, I think we need to attract GBA legal talents to come to Hong Kong. Well, you can see that the mainland is attracting our talents. Many of us have already passed the GBA exam. I took the first exam, and year in, year out, I have to renew the certificate, and I have to report on what I have been doing. So for the DOJ, I think the DOJ should work harder in helping us to go out. For Nansha, they have got 8 measures. They encourage Hong Kong law firms to start their business in Nansha, and they provide resources to help us in developing our business there. For many years, I have told the DOJ that barristers are not covered under that scheme. We don't actually have any method to sort of start our business there or open an office there. We can't even have a indication that we are available. So for our chambers, for our publicity, etc., I think they know nothing about that, and they don't know the difference between barristers and solicitors. For the GBA, they don't know this. They don't even know such broad concepts, so it was difficult for us to publicize ourselves individually. I think it's up to the government to have this breakthrough. It would be impossible for individual barristers or lawyers to sort of have the breakthrough. Well, they will, of course, tell us that we can't partner with you barristers. I think there is one that was successful in, but I'm not too sure about the actual mechanism. So I think you need to tell us how barristers' chambers can go into the mainland market, and whether their implementation measures can actually cover barristers. Barristers are also foreign-related legal talents. Whether we go to the mainland or whether how we are going to help the mainland to know us better. I think all such are issues that we hope the DOJ can help. Ms. Ho said that the Bar Association has done quite a lot in interfacing with the mainland market, like going with the DOJ delegation. But then just a few visits in a year would not be adequate. I think the DOJ should show more concern about the development of barristers, in particular young barristers in the GBA market. Now, in the interest of time management, please be concise in your answer. Poaching for talents, I think that's not unique to Hong Kong, the GBA. In fact, it is the trend throughout the world. The GBA market has offered a lot of attractive terms to attract our talents. It means that they treasure us, and they know that we are very rich in our foreign-related experience. For barristers, of course, the DOJ is concerned about the opportunities for barristers. Every time when we have a delegation to the mainland. We have the strong support from the Law Society and the Bar Association. We are very grateful because you have always been paying for your own expenses. So we are fully aware of the close cooperation with the two legal professional bodies. For the Hong Kong barristers working in the GBA or working on the mainland, usually barristers are engaged in court work. So they may not be able to work on court cases in the GBA. But then I think solicitors and barristers can equally become GBA lawyers. By having the qualification of GBA lawyers, they can go to Nansha or other places. So in this way, you can participate. But then, of course, you may not be able to engage in court cases in mainland courts. As to what will happen in the future, we are not sure. In some mainland courts, they do permit Hong Kong lawyers to take part in the cross-examination. Well, in fact, when it comes to cross-examination within the common law framework, they have seen the advantage of that. So there's room for development. Barristers can take part in the following kinds of work. Say, for example, making inquiries. Barristers can always give very good advice. And arbitration, mediation, again, they need the participation of people with a Hong Kong barrister background. So we will work hand in hand with the Bar Association so as to help the barristers here, in particular young barristers, so that they can take part in the development of the GBA and they can have more opportunities for their development. Let's enforce the 4-minute rule more strictly. If you have follow-up questions, I think you have to keep it for the second round. Next, Mr. Holden CHOW. Thank you, Chair. I'm going to share my view with you. For the GBA lawyer examination, we have seen a relaxation of the candidate qualification. Instead of having 5 years experience, you need 3 years. It is good. Young barristers, young lawyers can then sit the exam, and then in future they can become part of the GBA lawyer pool. I think it's good for the development of the legal services in GBA. Last year, I passed the GBA legal professional examination. To me, I think when it comes to the construction of the rule of law in the GBA, with more lawyers joining the pool, our contribution will be greater. I have a question concerning Hong Kong invested enterprises adopting Hong Kong law. We have made a start in Qianhai. Can the DFJ tell us the following? Now, having studied the relevant courses, we know that it is important to consider the foreign-related element. In the past, you might have a joint venture, but you might not be able to choose Hong Kong law as the law that applies. Now that we can try in Qianhai, there is allowing Hong Kong invested enterprises to adopt Hong Kong law. So what about the foreign-related elements? Mr. Zheng, you did mention this. You are promoting it, but then you have to take it step by step. Other than Qianhai, can we not look forward to extending it to other cities in the GBA? Well, having studied the relevant course, we know that foreign-related elements would be a very crucial point. Ms. Aoyang can assist in this answer. Thank you, Chair. Thank you, Mr. Zheng. For allowing Hong Kong investor enterprises to adopt Hong Kong law, well, the pilot scheme in Qianhai is a breakthrough. In other words, for civil cases, we have a slight relaxation concerning the requirement of foreign-related elements. Now, the Hong Kong invested enterprises adopting Hong Kong law is a very good arrangement. We would like to expand it. As the Deputy Secretary has said, for different cities to adopt this, it is up to them to consider their own case. But then we are grateful to the ministries and commissions because they are convinced that it is a good arrangement. It means more business for us, and we are able to facilitate the complementary nature of the collaboration of the two places. Currently, this is a pilot scheme. It is hoped that we can roll it out to other cities in the GBA. Maybe we can have another 1 or 2 cities. Probably you would imagine that Shenzhen would be a possible candidate. Qianhai is part of Shenzhen, so perhaps we can consider extending it to the rest of Shenzhen. That's the area, that's the direction that we are working on. And perhaps we can benefit from your feedback, from your experience of adopting Hong Kong law for Hong Kong invested enterprises. Thank you. Next, Professor Lam. Thank you, Chair. First of all, I'm glad to learn from the DFJ's briefing on the development that is Hong Kong laws can be adopted in a greater scope. Last year at the NPC, I had this proposal. That is, we hope that the GBA can share our brand of rule of law, namely common law. I was glad to get a written reply from the National People's Congress, but then I've been told that we need to take it step by step. It has to be gradual. Of course, we can't just have the interests of Hong Kong in mind. Mainland lawyers would have to consider their own case as well. We need to strive at a win-win situation. If we can expand the business for both parties instead of jeopardizing their business, then it will be good. I think the cake or the pie, so to speak, will just grow. I have taken part in providing legal service in a mediation case in a capacity as a Hong Kong barrister practicing common law. Well, I think you all know that I used to teach Chinese law, so foreign-related laws were the first lecture that I gave. Now, of course, many mainland legal talents are very conversant with common law. Many lawyers have had a legal training background in the Western world. And in fact, we have got many people with a training background both overseas and on the mainland. So you need to understand the development of the mainland. In different GA cities, they have also got training academies for foreign-related elements. I think it's best if we can have cooperation. We should be invited to give lectures. I think it's a matter of both being competitors and collaborators. By having collaborations, I think we can achieve a win-win situation. Common law is a common language. So if we can share the brand of common law of Hong Kong, then it will be a win-win situation. I think I am being very sincere in making this proposal. There is, I think we have to be patient. As Mr. has said, when a case goes to the court, I'm sure naturally they would welcome us. because our professors also got invitation to become adjudicators to go to Shanghai. So it will mature. So we don't need to become impatient. I'm a barrister. I have to say that the Hong Kong Law Society has contributed a lot in the GBA. They are the pace setters.
Last year, like Holden, I took the legal professional examination in GPA. People ask me why I took the exam because we weren't update our knowledge about what's happening in GPA. So they have made a lot of improvements. For example, in mediation and arbitration of intellectual property, they abide by international standards and they're very keen on implementing the decisions. So we have actually common interests. How are we going to tap the vast mainland market? Hong Kong has the advantage in the software, but our market is very limited. How can we complement each other and have a win-win situation? I'm very excited to see that, today I'm very pleased to hear from the Hong Kong Bar Association because you have seized the advantage out there. And we can also help with the development of the legal profession in Hong Kong. I've said years ago that no, we haven't yet opened up the market for barristers here. And now we've seen that the Bar Association and the Law Society have joined hands. I hope that we can set up the bridge and to link up the markets here and in the mainland so as to facilitate the development of the profession. We must try to achieve a win-win or even triple win situation. Then we can bridge the two markets. Don't say that we don't have enough businesses here in Hong Kong. Well, in fact, if we tap the market together and also the market in the one belt, one road markets, then that will be a vast opportunities for us. But I'm very pleased to hear from the DFJ, their report today, and also the directions going forward. Okay, any comments? Ms. Leung, I think in the legal area, she is an expert. And she has given us valuable opinions. I think together with the Bar Association and the Law Society, we would collaborate fully with them to help Hong Kong and help with the development of GBA as well. Okay, follow-up questions from two members. One is Maggie Chen. Thank you, Chairman. In the action plan, paragraph 29, it talks about development of technology. It says that in order to help individuals, enterprises set up convenient online dispute resolution services, the action plan here, I would suggest that we should use eBram more. The government has made several rounds of funding available to eBram. By the end of February this year, we've got 2,117 subscribers to the cloud services. And the arbitration and mediation cases that benefited from this service was limited. And even the Deputy Secretary of Justice of DFJ said that he's not satisfied with the number of cases that benefited from mediation. So how can we use innovative services to help expand the contributions of mediation and to develop the brand of mediation in Hong Kong? And also in paragraph 7B of the electoral paper, it says that you want to take forward the formulation and promotion of unified model rules on mediation and arbitration. In GBA, for any arbitration organization, they have their unified model rules. So how can a DFJ promote and formulate what you call unified model rules? If you want to unify the rules of all brands and put them under one brand. How can you achieve that? Get that done. Thank you, Vice Chairman. In the past, we have promoted law tech within the SAR in relation to online dispute resolution. And the Secretary mentioned earlier on that in terms of the progress of cases using innovative or online dispute resolution service, progress is very limited, and therefore we have tried to be more proactive, and going forward we can expect more proactive reforms ahead. We will closely monitor the progress. At the same time, as Ms. Chen has noted, besides the law tech promotion in Hong Kong, we support the use of, now that with the online platform in GBA, I think in the area we can see whether we can actually set up together in the entire GBA an online arbitration or dispute resolution platform. Actually, much has been done in the past year and in the GBA. And last month, I went to assign agreements with 2 cities, Zhaoqing and Foshan, a memorandum of understanding with them to spearhead more reform. So I hope that we can further facilitate the development of the online platform in GBA. And secondly, Ms. Chen asked about a core question, that is, whatever resolution services we want to promote, there are differences in the legal systems in the 3 areas. So how can we address that? Well, arbitration is one example. We would leverage our experience in mediation, and as you can see in my report, we have a model rules already for mediation, and the 3 areas have agreed on standards, unified standards, and we will, the 3 places would agree on an agreed panel of mediators. So we need to work together with the Guangdong and the Macau justice departments. We had meetings to deal with that. So based on our past experiences, we'll make use of the platform involving the 3 areas to promote unified model rules on mediation. And we have seen successful cases, and hopefully for arbitration we will do similar work in that area. Thank you. Quickly, because of time, sorry, I need to give Carmen Khan the time instead for a follow-up question. You may wait for the second round. I just want to supplement to declare that I obtained the mainland lawyer qualification in 1995. Still, I support Hong Kong lawyers practicing in GBA, including, that is, barristers, both barristers and solicitors. I do support the development there in GBA. I also agree with the member's suggestion that we should, like what Priscilla Leung said, we should actually enlarge the kick. And in Shenzhen is a good example to expand the scheme from Shanghai to Shenzhen. We need to let more mainland cities know they can opt for the Hong Kong law. We can tell them what are the incentives, and if possible, we can actually further discuss or explore the idea with more mainland organizations so they know what are the benefits of actually abiding by Hong Kong law. And also, we can, I think, use Shenzhen as the example and also include Nansha, which are relatively open And I think DFJ can consider extending Hong Kong law to those places. And in the action plan, in the last paragraph, DOJ says that it would report to LegCo and other stakeholders on the progress made as a result of the action plan. Yeah, that's your view. Yes, thank you. Okay, Maggie Chen, 3 minutes. Okay, I just want to follow up on EBRAM. On EBRAM, everyone knows that papers have suggested that the government has given EBRAM money, and yet in the action plan, it seems that we need to rely on the work of EBRAM, and yet its KPI or progress is very unsatisfactory. That's just my personal view. I hope that the DFJ will not just outsource the work to EBRAM and then say that way it's not doing a good job and that's it. You need to monitor it more because we've paid them public money and yet the online resolution service is so reliant on EBRAM. We need to closely monitor the work done and the progress made by EBRAM. Yes, as I said, for EBRAM, of course, we'll closely monitor their work progress. So please rest assured, we understand your concern. Since we have supported it with public money, we need to make sure that it's using the money effectively. And we will closely monitor the work of EBRAM and actively promote or encourage it to do its work well. Thank you. I think time's up for this item. So if there's no other business, I will announce that this meeting is adjourned. Thank you.